that depend on how often courts deny these subpoenas? I mean, suppose that you think courts basically order these subpoenas complied with 98% of the time. I don't know if that's true, but suppose it were.
I don't think still that would be enough. That's basically the set of facts that this court had before it.
So just to put a...
Wait, could I get the answer to my question?
Yeah.
Yeah, that's basically the set of facts that this court had before it in Clapper. Now, Clapper is most commonly understood as a case about the standing analysis that applies when there's no evidence that the government is specifically targeting an entity. But at page 413 of the Clapper decision, this court said, even if the respondents in that case could establish that there was particular targeting of the communications of the respondents in that case, that's still not enough for standing because it is contingent on a court order. In that case, it was the Foreign Intelligence Surveillance Court's order. And I think in Clapper, Justice Breyer pointed out in the dissent that there were 1,676 applications that were made. Over 98% of them were granted without modification. And this court still said that we don't rest our standing theories on guesswork about the actions of independent decision makers, particularly where those decision makers are courts.
So is that why Mr. Suri says it's bound up in the merits, the chill argument? Is that what your understanding is of his concern about chill as an argument?
I take that to be a different concern. Okay. I take that concern just to be that, as this court's decision in AFP illustrates, one factor that a court considers in the First Amendment analysis is the risk of a chilling effect, and that's relevant to the merits. Mm-hmm. But I don't think that means that you can't also consider chill for purposes of standing. It's a different kind of analysis.
So you say consider it, but because of this Clapper point, it's not shown here enough.
Yeah, I think that's right. Now, I do think that there may be a limited class of cases where a party could allege that it facts sufficient to support standing based on the issuance of a subpoena alone. And I think there are three categories of these kinds of cases. The first is where there's some kind of concrete harm from the issuance of the subpoena itself. And I'll come back to each of these examples if the court wants. Second is where the subpoena forms one part of the basis for a credible threat of enforcement of the underlying statute that actually regulates the conduct of the plaintiff in the case. And then the third is with respect to objective chill, it's been our consistent position throughout this litigation that the mere issuance of a subpoena without more can't establish objective chill. But
I think that's got to be your bottom line argument in response to Justice Kagan's questions, is that just the issuance of a subpoena cannot, no matter what the allegations are, be a basis for an objective.
So I think there is a caveat there, which I think
what's the caveat?
Brings together cases like Laird and Bantam Books, which is that if there are other government actions or other government statements that are linked to the subpoena that themselves would create an objective chill by establishing a credible threat.
But that's something else. You're saying that you have to have something additive, but just on its own, you're asking us to adopt a position that can never be enough.
Just on its own, without any additional facts,
right.
Statements,
but
actions,
in this case,
yes.
Weren't there? I mean, you had this Project Strike on the pregnancy centers. You know, the Attorney General had essentially, you know, what your friends on the other side would say, declared war on pregnancy centers. So if it is true that the non-self-executing subpoena is enough if it's in the context of other government statements, why wouldn't that be satisfied here?
Yeah, my friends on the other side don't let the actual factual allegations get in the way of telling a story about hostility here, but I think that story is just not borne out by the record evidence that's been offered here. So ultimately, I think at the end of the day, what they're identifying are policy disagreements that they have with the Attorney General. That's never been enough to establish hostility. It's never been enough to establish standing. I think with respect to the specific allegations, Justice Barrett, that you're noting, they point to a consumer alert that we had issued about crisis pregnancy centers, and they also point to a reproductive rights strike force. I'll take each of those points in turn. I think first with respect to the consumer alert, which is on JA 357 to 362. all that Consumer Alert is doing is telling people what the mission of organizations like crisis pregnancy centers are. I don't take petitioner to be disputing the point that we make in that Consumer Alert, which is that crisis pregnancy centers are entities that seek to deter women from accessing abortion care. They do take issue with our statement in that alert that there may sometimes be misrepresentations or false statements that are made in the provision of medical care, but I don't think it's evidence of hostility to have a targeted Consumer Alert that identifies a potential risk of misrepresentations, and then a subpoena that's specifically targeted to address whether those misrepresentations occurred. If it were otherwise, then every time the state issues a Consumer Alert about car dealerships or home contractors, that would somehow establish hostility. Yeah.
We don't need to get into the record here, but if it were the case that there were kind of this surrounding context, would that be enough on your theory?
It depends on what that context is.
But that might be a context in response to Justice Gorsuch's question where if there were more, if there was a non-self-executing subpoena plus some other background, we don't need to get into whether this is enough, but you concede in the abstract that might be enough.
Yes, we do. And maybe I could just illustrate with one or two examples of what might be sufficient to establish standing. So if there were statements made by a public official who's issuing the subpoena that they want to publicly expose donors to a particular organization, or for that matter, to all nonprofit organizations, I think that's the kind of credible threat of future harm that could be sufficient to get you in the door for a challenge to the subpoena. I think same thing if there are statements or actions specifically targeting the donors for enforcement, saying we want to bring to justice not just this organization, but all of its supporters. I think that could be sufficient. We just don't have anything like that in the factual record here.